decision today.
In the order, they reserve for themselves
But
the
they
power
can't,
to review when
but
necessary.
they cannot review, but they cannot give themselves more authority by that
Agreed,
than the
again.
law gives
I
them.
agree.
So, again, where do we get nowhere.
Well, in my opinion is this is the proper the starting point.
Circle.
Starting point for an argument. That's all this is. We'll see.
Hey, I feel like, what is that cartoon where the animal just chases its tail and eventually just becomes a circle?
Right.
That's kind of what I think this is.
You know, they will agree or disagree, and then life will move forward. I'm just here because I'm under the impression I had to do.
Well, you kind of do. It's your petition.
Pardon me?
I said you kind of do. It's your
Yeah,
petition.
no, I mean I had to be here as a ratepayer because I view this as a ratepayer dispute.
Well, look, nobody disagrees with you that this thing is a colossal yeah.
Well, if not this venue, then the Superior Court, and that may turn out to be the case. But my point is, I felt that this was the proper starting point.
Well, you can start
We
here,
won't end
but
here.
you're
That's the
not.
bottom line.
Well,
It may end here
well,
today,
it may end here with this commission.
but it won't end here.
Hey,
I know.
have at it.
I understand what you're saying.
Have at it. But, you know, I don't think we as lawyers can sit here and tell the commission that they have authority to do something that the general assembly does not give them the authority to do.
Well, the General Assembly did not limit their power.
It didn't give them any power to do anything, no. So what? So if they review it, so we have a review. But again, where does that get us?
I don't know the answer. No, I was here, wasn't here. Either until after the review is complete.
But they still don't have.
We don't know that. We think that.
John, we know it. The law says what the law says, and unless the law changes, we know what authority the commission has, and it's zero.
I got it. Thank you.
Okay.
And actually, she's here, so
Oh, okay.
we're going to Cape May.
Yes, yes.
Oh, terrific.
So you're going to break
Slowly.
Well, I had to pay that back.
Hydraulic pressure.
You have two. Okay.
Way back in the dark. Right?
What are you doing?
Public comment. Being that away.
I see.
Hey, well, you do a great job.
Okay, there's Jason. No, I don't see Amy. She's not here at all. Oh,
We need another 6
what?
It's fun. It was fun.
Me?
Yeah, it was fun.
What about?
It was fun. Okay.
He's been away. He said it was fun.
Oh,
It's true.
oh, it was fun.
Is it 1 o'clock?
Yes.
Good afternoon, everybody, and welcome to the Delaware Public Service Commission meeting of October the 9th, 2018. It's nice to see Mr. Nichols in the front row. Everybody came to see me back from vacation. Thank you very much. We have the reading of the meeting. First of all, before I do anything else, Jason Smith, come up here. Come up here, will you please, young man? Now, Jason, I don't know why I'm asking. I don't have anything to give to you. But come on up anyway. You know, everybody. Jason is leaving us, and he's going to go to the Comptroller General's office. He tells me that he aspires to be another chief deputy, just like one of his predecessors who's here in the room, Courtney Stewart. So all I can say, Jason, is that we sincerely appreciate all the work you've done over all the years. I mean, you're an inspiration to people who know you. You do such great work, and we certainly appreciate sometimes you'll put a party together or two. That also reminds me of Courtney Stewart, who was very good at maybe the morale situation, which was terrific. So we want to extend our thanks to you, and we want to express our best wishes to you and your career as you go forward. Just remember us fondly, and when you have a chance, a little extra dollars for the employees would be nice. And but best wishes to you, Jason, and thanks very much. Any commissioners want to make any comments about Jason?
I want to say thanks, Jason. We have another staff member also leaving, do we not?
We're going to say regards to Amy the next meeting. We can only take so much loss in one meeting.
Thank you, Jason.
So best wishes.
Good luck
Thanks,
to you.
Jason.
Mr. Chairman, I would say something in connection with Jason, and that is he is the best hearing examiner that I've ever appeared before without the title of hearing examiner.
Thank you, Mr. Geddes. Okay, Commissioners, we have the reading of the meeting minutes of September 25th, both the public and the executive session. Are there any suggested changes or modifications to the aforesaid minutes?
The only thing I would suggest, Mr. Chair, is that on page 3, that Jerry Platt's name be corrected to say Platt instead of having the S on it.
Is that a motion to approve the minutes with that correction?
Yes, please. I second it.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Are there any opposed or any abstentions? The motion carries. Thank you, Commissioner Conway. Consent agenda. Does anyone wish to have a matter on the consent agenda taken off the consent agenda and placed on the regular agenda? Would anybody care to make a motion to approve the consent agenda?
I move to adopt the consent agenda.
And I second?
Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? The motion carries. Now we're going to go on to the regular agenda. Number 1 is in the matter of the adoption of regulations governing the administration of the electric and natural gas utility distribution system improvement charge. And we have Mr. Geddes, please.
Yes, Mr. Chairman, members of the commission, this is a opening order that would initiate a regulatory docket to deal with the DSIC legislation as passed by the legislature, and specifically to develop regulations for that particular piece of legislation. The proposed regulations that would go out for publication and comment are attached, and staff supports the opening of this docket to review what the appropriate regulations should be in connection with the legislation. Thank you.
Thank you, Mr. Geddes. Ms. Iori?
Thank you, Mr. Chairman and Commissioners. The public advocate does not take a position on this matter.
Mr. Goodman?
Thank you, Chairman Winslow, Commissioners. I think it's perfectly fine to open the docket. We're not going to try and object to that. I don't think we have any reason to. I just don't want, I just think it's fair that we make it clear that we do see some issues with these rules, but they'll be addressed in the normal course of comment and hearings and all that. I guess the only other thing that I think I want to make sure the Commission is aware of is that we're in the process of preparing our DSIC filing right now that you'll get, I believe, next month. That's being done, as the statute says, under existing rules. So I just thought just clear the air about that. But yeah, I think this is appropriate to open, and we have no objection to it being open.
Thank you, Mr. Goodman. Mr. O'Brien, any comments?
No, we have no objection to opening the docket. Just has no objection.
Thank you, sir. Commissioners, any questions?
Mr. Chair, I move that the commission adopt order number 9282 as submitted.
Second the motion?
Any discussion on the motion to approve proposed order 9282? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you, gentlemen and ladies.
Mr. Chairman, can I take a point out of order before we move into this?
You have a point of order?
No, out of order.
Point of out of order?
If I may.
Yes, sir.
I was just notified by the commission secretary that when the vote was taken to approve the minutes of the last meeting, since you were not present, we should mark you as abstain.
Yes, that's true.
Thank you.
He did.
Also, a quick question. Was that motion suitable to approve both the regular and the executive minutes, or do we need
Yeah.
another motion?
I-
If,
I think we got both.
okay,
It was
thank you.
both. Thank you. Thank you, Mr. Chairman.
Thank you, sir. The next matter is in the matter of the petition of John Nichols requesting the Public Service Commission open a docket to review the qualified fuel cell provider tariff. The commission invites Mr. Nichols to the table and any other parties to this effort. Before we begin, the commission, this is a motion, and ordinarily the commission hears from the parties, in other words, the staff and DPA, and in this particular circumstance, Mr. Nichols, and generally don't hear from anybody else. Did anybody else come here expecting to speak on this matter in support or in opposition to the motion? You'll be permitted to talk at a public comment session, but that will be subsequent to this discussion we're having right now. Sir, did you want to come forward and say something? I apologize. Would you like to come forward and speak on behalf of either before or against this motion?
I would speak for it.
For Mr. Nichols' petition or for the motion to dismiss? Okay, sir. You're not one of the parties, but if you want to, as part of public comment, want to come up and make some comments, brief comments, we will listen to you for a couple of minutes. Not that we wouldn't want to listen to you for a longer period of time, but hopefully you'll be able to express yourself in a couple minutes. You want to come up and identify yourself, have a seat, make yourself comfortable, and let us know what you have to say.
Okay, thank you very much. My name is John Greer. Was a licensed professional engineer in the state of Delaware for the last 40 years and now retired. I've been concerned about the bloom ever since it was passed. Should I be speaking into this?
Yes, sir.
I submitted some written comments, and just concerned about how unfair this is to the general public. The cost of the bloom, I've looked at the cost of the bloom energy to the public is about 20 cents last year, 20 cents a kilowatt hour, which they sell for about 4 cents. And so the public is paying a premium of 16 cents for bloom energy. It's 5 times they pay 5 times the market price. It's a burden that has been about $200 million total, which is spread out over all the ratepayers. It will be $750 million by the end of the contract if it goes as it is. And the public gets no benefit. Their claims of having clean energy are not really true. They generate solid hazardous waste, which is toxic chemicals removed from the feed gas. They produce volatile organic compounds because they do not process ethane properly, so you get a lot of unburned natural gas coming out. They produce nitrogen oxide pollution because of the high operating temperatures. And they produce just as much carbon dioxide from natural gas as does combustion. They claim it's not the same as combustion, but the net chemical reaction is the same. Carbon dioxide plus oxygen makes carbon dioxide plus water vapor. It is the same whether it goes through the bloom or through a combustion process. So the bloom as fuel cells are very costly, and they are not clean, and we should try to do everything we can to relieve the public of this burden. So, thank you very much.
Mr. Greer, thank you so much for coming forward. Appreciate it.
Thank you, sir.
Are you part of the Me Too movement? If you are, please come up. And you have to, please give us your name. We're not so sure we know who you are.
My name is Gary Myers. I'm a resident of Rehoboth Beach and a DP&L customer. I had filed some written comments with the commission last week. I come before you to say I don't have a position with Mr. Nichols or staff or the DPA on the particular motion, but to urge the commission not to, however it votes on that motion, not to let this opportunity slide by. I think you have an opportunity here to address some questions to Bloom about exactly where the project's going. They made representations before you about jobs, manufacturing facilities, and so forth. They haven't come to fruition. I think it's a perfect opportunity for the commission, excuse me, for the commission to address some questions to Bloom to find out when and where they're going to fulfill their representations. So that's my point. I had a proposed set of questions I sent to the commissioners for your review that you could propose to Bloom based on the representations they made. So regardless of how you come out on the motion, I think the opportunity here is to develop a public record exactly how and when Bloom's going to live up to its commitments it made to you in 2011.
Thank you, Mr. Myers. Commissioners, any questions at all? Mr. Lawson, are you going to be speaking, sir?
If I may.
Please identify yourself, Senator.
I'm Senator Dave Lawson. I represent the 15th Senatorial District, Western Kent County. I'm very concerned with the Bloom Energy contract drawn up by the agreed to by the legislature, drawn up by then Governor Markell and Colin O'Mara and other players. I think we were sold a bill of goods and it's a job creator, and that there would be certain milestones met, and they were not met. They've not been met all along. We were told that it would be 70 cents to $1 to each homeowner. Where is it now? Pushing 5? The customers of DP&L do not deserve this kind of treatment by the state of Delaware. And I'm prepared to go back to the legislature and see if there isn't some way to rectify the mistakes that we've made against the public here in the state. I think we've done a miserable job, we as a legislature. That's an agreement, a contract drawn up by legislation that was just despicable. We shouldn't have done it. It was done, however, but it was sold snake oil. And a lot of us bought it. I think that we can do better here. I think that you all have a chance to have this review done. And I don't think it would hurt anything. It's a review, not action, just a review. Where are we? I think any business would do this. They have a policy in place, they do something, they reevaluate it. They go back and look at it again every so often. We haven't done that. The only thing we've seen is the tariff, tax, whatever you want to call it, continues to go up, and the customers of DP&L continue to get ripped. That's wrong, and you, as a commission, have a chance to take some steps to see just exactly what's going on. Maybe it's not a ripping, maybe it is, maybe it's legitimate, but we as a legislature don't know, as the public doesn't know. But with this petition for a review, I think that a lot of answers could be had to a lot of questions that are out there. I appreciate the chance to speak with you, and I hope that you see fit to okay this, even though I know there's a letter out there already written. So I thank you.
Thank you, Senator Lawson. Appreciate your being here.
Mr. Chair, if you don't, Ms. Senator Lawson, might I ask a quick question?
Sure.
Thank you. Do you perceive this issue in front of us as one of a contract issue or a rate issue, sir?
Oh, it's a rate issue.
Thank you.
There doesn't appear to be any more questions. Thanks, Senator.
Thank you.
Okay, let's get to the motion. Ms. Iori and Mr. Geddes, do you have any comments in support of the motion that are not contained within the four corners of the motion, which was very long and very thorough and very much to the point about the law?
I'll start out, Mr. Chairman. I think it's the petition that the commission should take up first. With regard to the motion to dismiss, I think it is clear, but I do believe that Ms. Iori and myself would like an opportunity to respond to any comments that Mr. Nichols makes in connection with his petition.
Yes, so that will occur.
Okay.
Ms. Iori?
I agree, Mr. Nichols should proceed, it is his petition, and then Mr. Geddes and Mr. Slater, and I will address the merits or not of the petition.
Thank you, Ms. Iori. Mr. Nichols, it's your turn. Please.
Thank you, Chairman Winslow. It's a pleasure to be back. Not here very often. I try not to waste the commissioner's time.
Mr. Nichols, you're not going to waste our time. We're very happy to be here. It's a very important issue, and we welcome your remarks.
Thank you for considering it. My petition was written because it's time to look at the Bloom tariff, to review the Bloom tariff. 85% of what was written by counsel for staff and the Public Advocate's Office I agree with. In fact, I wrote it. I wrote what they wrote, that this agreement is between Delmarva Power and Bloom Energy, and that the tariff, once it was adopted by the commission, was set in stone, shall we say, that the ability to change it was very limited. So I'm not asking the commissioners to change anything. That's the 15% disagreement. I'm not asking the commissioners to do anything that would impair the revenue stream of Bloom. Nothing. I'm simply asking for a power that the commission reserved for themselves when they approved the Bloom tariff to review when necessary and proper. One would have to say, based upon what's transpired thus far, that Bloom hasn't met its obligations. And the question then becomes why, and what were the circumstances surrounding the approval of the tariff, and what can we learn from it? I don't know what would come out of a review. I have no idea. But it seems to me, as a ratepayer, I would have standing before the commissioners to petition to open a docket to review it. To what end? I don't know. I truly don't. I would imagine that there are some limitations. In fact, I'm sure there's some limitations, no imagining about it, as to what the commission can do. But that doesn't mean the commission can't review it, if for no other reason other than to learn from past experiences. Mr. Geddes, in his motion to dismiss, says the General Assembly has not given the commission the authority to change the tariff under any circumstances. True. True. They have no legal authority to change the role of Delmarva, as it merely operates as the agent. True again. The only two parties, Bloom and Delmarva, may amend the terms of the tariff. True. Again, true. But my dispute is in the proper venue. This is a ratepayer dispute. The last point that Mr. Geddes raised is any action with respect to the terms of the Bloom project as inconsistent with the statutory required provision can't be changed unless the two authorized parties, which are Bloom and Delmarva Power, agree to such changes. Also true. My hope is that a review will lead the two parties to reconsider the terms of the tariff and perhaps offer relief from the cost of paying for this very expensive electricity. Maybe it won't. I don't know. I have no idea. But I agree, the commissioners on their own cannot take any action. But that doesn't mean that Delmarva Power and Bloom Energy, if only in the interest of public relations, can't decide that they can do something else to lessen this, and it is a burden, lessen this burden on the ratepayers. So I'm asking that you open a docket to review and let that review take us where it may. I don't know where it's going to go. I have no idea. But to just dismiss this because the commission on its own can't take any action, I think what it does is it deprives the citizens and the commissioners from a very, very valuable learning opportunity. If mistakes were made, what will they be? What changes can we make going forward so that we don't repeat the mistakes of the past? So I don't think it matters. The commissioners on their own can't take any action. I think it matters the commissioners learn from the actions that we're taking. Yeah, I have a PowerPoint presentation, but I only put it together if it was needed by the commissioners in the event that they wanted me to speak to my petition. But I assume that all have read it, and I'm happy to answer any questions you may have regarding my petition, and then to address concerns that attorneys for staff and the PSC have. Thank you very much.
Thank you, Mr. Nichols. We've read the petition, and it was a very thorough petition setting forth a lot of facts we're all aware of. So I don't think it's necessary to do the PowerPoint, but we'll give you a chance to talk again after you've heard how many times we're going to go back and forth here. But let's start off by asking Mr. Geddes to make whatever comments you feel are appropriate.
About 41. Mr. Chairman, members of the commission, as you indicate, I think the motion to dismiss is quite clear. And for some of us who were here 7 years ago, not specifically here, but in Legg Hall, when this contract was considered by the commission, there were some concerns raised about it. In particular, it was a binary choice. There was only a yes or a no. And if you look at this paragraph in the findings, opinion, and order, in connection with docket 11-362, you'll see that the commission stated that it recognized that there was no ability, based on the statute, to make changes. And the petitioner in this case has admitted to that. And once the commission approved that contract, it abrogated all of its authority with regard to it, except in two small situations. One with regard to miscellaneous costs, and the other if there was some error in the calculations. But other than that, the commission was stripped of any authority to further consider the agreement. And that was as a result of the legislation. And as it says there are no do-overs. This is a decision that was made in 2011, and there was no provision for the commission to further modify it. Can I have 44? At the time you approved it, there were many numbers floating around. ICF, which was hired by Delmarva, suggested that this would only cost approximately $1 more for the ratepayers. The commission staff consultant thought it would be $1.43. There was only one individual, Mr. Stevenson, CRI, who suggested that it could be as high as $4.23. And remember, the Blue Water cap was $2.42. So when staff reviewed this, it reviewed what it thought were the levelized costs and also the projected benefits to the state from having this investment made. But as this paragraph indicates, what we have in front of us, this is in 2011, does not tell us what the costs are going to be in 2018. Your right to approve it and your obligation to approve it or reject it were based on the best estimates of the experts that were in front of you at the time the hearing took place. And with the lens of 7 years of history, I'm sure the decision that you made, or at least some of you made, perhaps may be different. But unfortunately, the statute does not give you that right to go back and review this. There are no do-overs. Mr. Nichols recognizes that, but then he advocates that you should review the situation, to review the 7 years of history and conclude what you conclude. Well, let's assume, for sake of argument, that everything that Mr. Nichols said in his petition is true. What does the commission do with that? Those are facts, assuming they are correct, but let's just assume they are correct. What's the remedy? There is no remedy before this commission, because the commission gave up its authority to correct any issues other than the two little ones I commented on when it approved the contract. So you are in a straitjacket. You don't have any discretion here. It is what it is. The statute is clear. No one disagrees with it. And as one commissioner said at the time, and I'm not exactly sure who this was, in footnote 9 in the decision, we have a tariff with one entity and an agreement between the state and some other entity not obligated by the tariff taking up obligations for a third party. That's pretty convoluted because Bloom is not a regulated utility. Delmarva, of course, is, but one of the parties to this transaction is not subject to your regulation. So query, as Mr. Myers suggested, how does the commission ask Bloom questions that they don't want to answer? Now, you can, of course, ask the questions. Anyone can ask the questions, but what if Bloom hypothetically decides it doesn't want to answer them? I don't think this commission has authority to require them to answer anything. Maybe the state does, because Bloom is obviously doing business here, but this commission doesn't have that right. This commission has abrogated all its rights under this contract because the statute required you to do it. Obviously, the scriveners of this did not want the commission to come back and suggest modifications or alterations. And in fact, the contract is so unique that even the state in the statute said it would not come back. In 364H, specifically, the state shall neither limit nor alter the revenue property and all rights thereunder until the obligations are fully met and discharged. So under this statute, it says that the state cannot modify, alter, or change unless Bloom is guaranteed all the revenues under the contract. So I'm not sure what a review would accomplish. The commission has many matters before it, but there is no viable remedy. The commission, unfortunately, hands are tied. There's nothing that the commission can do here. We're empathetic. Everyone understands that the costs are higher than projected, that maybe some of the commitments by Bloom have not been fully met, but those were also recognized as potential risks the day that the commission approved the contract, and nothing has changed since then. And unfortunately, this is not the forum where Mr. Nichols and others can find relief. Thank you.
Thank you, Mr. Geddes. Ms. Iori?
Thank you, Chairman Winslow. I just have a couple of things to say, and then I'm going to turn it over to Mr. Slater. I am addressing the legal arguments only, and the first argument, and you don't have Mr. Nichols's PowerPoint, but I expect that we might hear that argument when he gets another chance to speak. So I'll just go ahead and address it now. And he pointed to a Superior Court opinion issued in 2015 that said that that was brought a Bloom issue before the Superior Court, and in that case, the Superior Court said that the dispute belonged before the Commission. And that was based on the Commission's authority under Section 201. The Court never addressed the authority or lack thereof that was in Section 364, and that is what governs here, not the general grant of jurisdiction over a utilities rates. With that, I will turn it over to Mr. Slater.
Good afternoon, Mr. Chairman and Commissioners.
Good afternoon.
Mr. Nichols has been a longtime proponent of removing the qualified fuel cell provider tariff, or also known as Bloom, charge from Delmarva ratepayer bills, including his own. And actually, if memory serves me correctly, he was opposed to the Bloom deal from the beginning and may have even provided comments to the General Assembly to that effect. along with Mr. Stevenson, whose numbers proved to be yet again right on the mark. In January 2017, when I was up for confirmation by the Senate, the first question that I got was actually from a legislator, and they said, how do we get rid of the Bloom charge? And my comment back to the legislator was that there was no clawback provision provided by the General Assembly on behalf of ratepayers. That is true. The state was able to claw back some of the money from Bloom missing the jobs targets, but there was no similar provision for Delmarva's customers. Furthermore, the contract even allowed that if Bloom left the state before the end of 20 years or 21 years, that Delmarva ratepayers would continue to pay the surcharge. That actually recently changed because they now have an IPO, and in that IPO we learned that 10% of their overall revenues are Delmarva ratepayers. Let's make no mistake about it, this was a horrible deal for Delmarva ratepayers. Delmarva Power, and especially its ratepayers, should not have been used to promote economic development through a utility charge. A tax would have been a more appropriate measure. However, that's not what the General Assembly decreed. Unfortunately, this petition doesn't resolve this issue. This is a matter of a signed contract, a contract that locked in costs to Delmarva's residential, commercial, and industrial customers for 20 years. It should be a warning for other projects that would do the same thing to Delaware utility customers. Through this petition, Mr. Nichols suggests 3 options, although asking Delmarva and Bloom to speak could be considered an option all by itself. His first option was to update the equipment used in the Bloom boxes. Bloom has said it's imminent that they're going to change Florida and California's boxes to biogas at landfills and agriculture sites. Second, review the implications of shutting down the fuel cell facility. And lastly, recommend legislation to replace the qualified fuel cell provider tariff with a taxpayer-funded subsidy payment. And so I'm going to try and address each one of these. Regarding the options mentioned through this petition, and as Mr. Geddes has eloquently explained, the Commission could request that Bloom and Delmarva talk, but the Commission can't make Bloom talk to Delmarva because it doesn't have any regulatory authority over Bloom. In fact, the legislation requires any dispute involving Bloom to be brought not before the Commission but to the Superior Court. With respect to updating the equipment, again, the Commission could ask Bloom to consider this, but because it has no regulatory authority over Bloom, it can't make Bloom do anything. With respect to shutting down the facility, the agreement made it so that any change or repeal of the law would mean Delmarva's customers would be responsible for immediate payment of the entire amount due to Bloom. By Mr. Nichols' own calculation, that is some $500 million. That would place an enormous burden immediately on the backs of all classes of Delmarva ratepayers. Residential customers would receive bills north of $700. Large industrial customers could see bills of $15 million due immediately. Mr. Nichols admits that this could be the case. That's unacceptable to me and a major reason why we have our disagreements with his petition and our motion to dismiss. Again, this is a contractual issue and one that does not leave any room for you to maneuver. We can argue about the cost of the project, and we should. As I've said over and over again, the levelized cost of energy is a fallacy. It's used to make the numbers come out lower than consumers actually see on their bills. And as you know, consumers care about what they actually pay on their bills each month, not the tertiary potential benefits. But what the projected average cost will be over 20 years. This is a maneuver to make the cost seem lower by looking at the overall project cost and potential benefits over 20 years. The actual monthly cost of Delmarva customers, as we know, is much higher. In addition, it adds all kinds of externalities that are difficult to calculate, which may or may not be realized but are incorporated to lower the perceived cost of the project. For example, it includes capacity and energy market payments, and at least the example of the PJM capacity payments. We know those payments could go away for state-subsidized resources like Bloom, which means Delmarva customers, again, are going to end up wind up paying more. As I've said before, Mr. Stevenson was right. The levelized cost of energy promise will never be reached. Delmarva's customers will always pay more than the $1.30 or $1.40 cost quoted to them based on 20-year levelized costs. But again, there's nothing that the PSC can do about the rates that are charged. The PSC and Delmarva Power as a pass-through entity did not set the rate for this project. That was part of the contract and the legislation. As you're aware, I've had my share of disagreements with elected officials Public Service Commission, Delmarva Power, other utilities. However, in this case, this complaint, and I don't mean that in a negative sense at all, can't be addressed here. The Public Service Commission approved this project as after the General Assembly passed a law allowing for the qualified fuel cell provider tariff. The law didn't give the commission much wiggle room, as you've heard from Mr. Geddes. But you were abiding by the law then, and you have to abide by the law now. Finally, with respect to replacing Delmarva ratepayer subsidy to Bloom with a subsidy funded by all ratepayers, or all taxpayers, sorry. One could ask if Delmarva suggested this when the Bloom deal and legislation was being negotiated, and if it didn't, they could ask why. But again, that's water under the bridge. It's already signed. The fact is the Commission cannot order this. Such a change can only come from the legislature, and to pass a new tax, Article 8, Section 11 of our state constitution requires the agreement of 3/5 of the members of both the House and the Senate. So while I'm sympathetic to Mr. Nichols' petition and wish that we had a redo of this, I also acknowledge that the General Assembly severely limited the Commission's options, both at the time of the Bloom project came before the Commission for approval and now after the Commission has approved it. And that's why we joined staff in the motion to dismiss this petition. Thank you.
Thank you, Mr. Slater. Mr. Nichols?
The reason for my petition, as Ms. Iori indicates, has a lot to do with Whipple versus Delmarva Power and Light, which is how they were referred to in the case. Ms. Iori is correct in that the Superior Court did not rule on the merits of the case. They didn't look at the statute. What they did is dismiss the case, saying that it was a ratepayer dispute. The proper venue for ratepayer disputes was the Delaware Public Service Commission. Now, that's my interpretation of the ruling. Opinions vary. I'm here for that reason alone. Based upon my reading of the ruling, it is DPSC's responsibility to preside over ratepayer disputes. Now, Bloom, this has been called both a rate case or a ratepayer matter, and it's also been called a contract. It's both. I'm not here to challenge the contract. I'm here to challenge the ratepayer aspect of the Bloom tariff. And I'm here specifically because my understanding in Whipple versus Delmarva Power and Light is this is the place to begin. So I'm here to begin. I don't know if Mr. Myers is still here, but I'm sure the commissioners have reviewed his public comments. In his comments, he says, and for those in attendance that don't know, Mr. Myers is a former Deputy Attorney General and hearing examiner for the Delaware Public Service Commission. That doesn't mean his words carry more weight than mine, but I think it's worthwhile to mention them. In his public comments, he says, the Commission still has the authority to review the monthly Bloom energy payments for manifest error. He cites the Title 26, Code Section 364D4. Well, that is a question, isn't it? Has manifest error been committed? Guess what? I don't know. And we will never know, and the commissioners will never know, unless they agree to a review. Whether or not they do that remains to be seen. It seemed to me that, but I don't follow every action before the commission. It was a little odd to have the order to dismiss the petition before the oral arguments were heard, but maybe my petition was so clearly inaccurately placed that that was deemed necessary. I presume that was the reason. But I'm here to defend it, my petition, and I'm here to answer any questions you may have. The petition was rather lengthy because three of the commissioners that are now here were not involved with the Bloom tariff. My goal in writing the petition was to provide a historical understanding of what transpired. Chairman Winslow knows full well that I objected to this, as does Mrs. Conaway. She was here when former DITO Secretary Alan Levin was here in Dover, saying that he had a black box model, I'm quoting Secretary Levin, that proved that the jobs that Bloom said would be created. I countered that with real-world experience from the Spanish study, which showed that in Spain, because of public aid to alternative energy, they call it renewable. I hardly think that it is, but that's another matter for another day. jobs were lost. There's a long way to go down that road, and much to review. But that can only happen if the commissioners agree to open a docket. I don't see what harm it causes. I don't think it's a waste of time. Everyone has acknowledged that this was not a good deal for the Delmarva Power ratepayers. To say that, well, we're not going to do it because there's no way we can compel Delmarva and Bloom to reach an agreement, maybe that's true. Maybe they won't reach an agreement. But I want to get one thing on the record, and this will be my final comment, so bear with me, please. This was not a well-coordinated effort, to say the least, but I'm surprised that the Delaware Department of Natural Resources and Environmental Control is not here, because they were responsible for this too, as were many of the people who worked for the department. Bloom was offered a permit to generate electricity to be sold directly into the grid based upon a maximum consumption of heat rate, a maximum consumption of energy, which is referred to as a heat rate. That number is 6.60 millions of BTU per megawatt hour of electricity generated. I've mentioned this before at the commission hearings. We know that the tariff was designed completely different from the permitting. Under the tariff, Bloom is permitted to bank BTUs of gas that aren't used, and then once they exceed the tariff allowable limit of 7.55 million BTUs per megawatt hour, then they have to draw against their bank. They're already in the bank. They're drawing against it. So the question then becomes, is that manifest error? Maybe it is. Maybe it isn't. Maybe it's not the purview of the commissioners to deal with that issue. Maybe some other entity takes that up. But that may not occur unless the commissioners agree to the review. There's no doubt whatsoever that the permit and the tariff do not coincide with one another. None. They exceed the allowable heat rate, which Bloom, in their documents, said would be no more than 6.60 millions of BTU. But the tariff was never written that way. I wonder why DENREC's not here to explain that. But that's something that could come up during a review. Delmarva might look to that and say, you know what? Yeah, maybe Bloom can do something to upgrade the performance of their fuel cells. Allegedly, their new fuel cells are more efficient than the old fuel cells that have been deployed in Delaware. Maybe, again, in the interest of good public relations, since they have gone ahead with their IPO, they would opt to make some concessions. But most assuredly, they're not going to do anything that would change the way they operate their fuel cells unless they're called to account for the way in which the loss of efficiency, which was not covered when Bloom was brought to Delaware. There are many other issues, but I'm not here to debate or discuss all of the issues that would be available to us during review. I'm just saying that there is clearly facts that need review. The use of natural gas, the lack of efficiency being foremost among them. So I'm respectfully asking that you do it. I don't think it's a waste of time. I don't think any review is a waste of time. But, and again, I believe Whipple versus Delmarva Power says this is the proper venue, but perhaps it's not. We shall see. Thank you.
Mr. Nichols. Mr. Geddes.
Short response.
Short, please.
It will be short. I will try to make 3 points. Most importantly, the contract is not with Delmarva. The contract with Bloom is with the state. And that's a big difference. Delmarva doesn't have any authority here either, because the state is the one that negotiated the contract, and specifically in paragraph 49, for those of you who sat on the commission at that time, you recall that staff negotiated very hard to deal with the hypothetical, what if they didn't build the manufacturing facility? And the state, we negotiated with the state with regard to that, and Mr. O'Mara in particular. And paragraph 49 of your earlier decision, the termination agreement was specifically modified to address staff's concern regarding the lack of any financial compensation if the facility wasn't built. As a result, the state negotiated additional protections. The state negotiated all these, not Delmarva. So whatever review you want to have, or whatever proceeding, has to be with the state, not with Delmarva, because they're not really a stakeholder here. Secondly, the manifest error is something that this commission looks at, and staff in particular, Ms. Knotts particularly, looks at every month, every time they make a filing to make sure that the addition is correct.
And we make it part of the public record so that anyone who is out there would like to review that and quibble with staff can do that.
But it's an accounting issue, that's all. It has nothing to do with all the other substantive issues that Mr. Nichols suggested. And finally, with regard to the Whipple case, I'd ask Ms. Iori just to respond briefly. Thank you.
Oh, thank you. Again, Mr. Nichols is correct that the court said it was a ratepayer dispute, but that's as far as it goes. The court didn't go further and look to see whether there was anything in Section 364, because it never came up, as far as I can tell from the opinion. 364 governs the commission in this particular situation. It is not a ratepayer dispute. Mr. Nichols isn't claiming that the amount that is on his bill for Bloom has been calculated incorrectly or is an incorrect amount. He's saying it shouldn't be there at all. And while we don't necessarily disagree with that, that is not the kind of ratepayer dispute that Whipple was intended to address. Thank you.
Thank you, Ms. Iori. Commissioners, have any questions of Mr. Nichols, staff, DPA? Commissioner Gray.
Thank you, Mr. Chair. So, from my experience on the business side in a different life, contracts usually dictate the rates. So wouldn't we need to have authority to change the contract in order to alter this tariff? And who owns the contract? Which state agency or authority?
The contract, if we say that that Delmarva Power is only the agent for Bloom Energy and they're just collecting the money, then the contract, as Mr. Geddes indicates, would be between the state of Delaware and Bloom Energy.
Are you saying the state of Delaware, i.e. the governor of Delaware, the legislators of Delaware? What authority within the state owns the contract?
That would be a question that would have to be directed to Mr. Geddes. I believe that the revenue stream is due Bloom Energy based upon the monthly approvals as the cost for the tariff that are approved each month by the commissioners. I'm not clear, but Mr. Geddes seems to have the answer to that question. Who or what agency within the state of Delaware, what agency governs? I'm not sure.
Would it be reasonable to assume that the Department of Economic Development for the state had signed up to this agreement? Can anyone answer that question?
Go ahead.
Can I?
No, please.
Thank you. Commissioner Gray, I was going to suggest that the contract is within what is no longer DITO, but at the time was DITO, yes.
So an added complexity is now we have a completely different entity and DITO doesn't exist anymore, right?
That's accurate.
Yes.
Okay. So let me ask two other questions, please. And this, I think, is for Mr. Slater. If the Bloom surcharge was converted to a tax subsidy by the legislators, would that change trigger an automatic total liability to Bloom?
Yes.
All right, thank you. Third question. Who owns the permitting and performance authority that you've addressed, Mr. Nichols?
It's owned by Diamond State. Bloom has a minority ownership interest in the revenue stream. Most of the, I think this is your question, I'm responding to it, I believe. I'm clear. What's your question?
Let me clarify this. You mentioned something about the efficiency, they have a permit, they're not
thank you.
performing. So
Well,
who has the permitting and performance oversight
The Delaware
authority?
Department of Natural Resources and Environmental Control.
Okay.
May I
Sure.
elaborate? I do have a problem with the way in which the permit is being submitted for that reason. It is a ratepayer issue. I believe that they should be limited to receive payment for a net amount, without getting through the mechanics of how they get paid, that allows them to collect no more than would be permitted if their heat rate was 6.60 millions of BTU. That is what they are permitted. The tariff was structured differently. What accommodation would they make? I don't know.
So what
Sir.
I think I've heard in those responses is that DENREC should have the appeal for the performance issue or lack thereof. DITO perhaps as the owner of the contract should be sought out as a place to resolve the underlying terms and conditions that drive the tariff to Delmarva customers. So I'm inclined to believe what you said in the very beginning, that the commission really doesn't have authority to make some of the changes that you would like to see.
I agree.
No further questions.
Mr. Slater, did you have some other comment? No?
Mr. Chairman, because I believe this petition is before the wrong venue, I would move that this commission adopt order number 9283.
I second it.
There's a motion on the table. Senator Lawson, I'm very, very happy that you are here today, sir, because as a former member of the Senate and as a person who may have been in a room 7 years ago and made a comment or two about this issue we're talking about, unfortunately, it looks like we're going to have to pass the baton to you and your fellow members of the legislature, because we really don't have the lawful authority to do what Mr. Nichols wants to do. Mr. Nichols should be very proud of himself for the fights he puts up on this issue, but I think if he spends maybe even more time down in Dover, perhaps that's where we'll get some answers from that we've been discussing all afternoon. So it's a good fight, but we don't really have the lawful authority to take up that fight. So.
I hear you, thank you.
Yep. I'm sorry, Mr. Greer, but we're not having any more comments from the audience or witnesses. Yes, sir, you can ask me, you have a question? Okay, please go ahead, sir.
Thank you. I'm sorry, I was in my other comments. I'm under the impression that there was a cap provided in the legislation, a max to protect the consumers, that there was a cap and that it's not been enforced. Certain maximum.
Mr. Slater.
That is the cost cap issue, which is, you're dealing with in another docket, but doesn't affect what's going on here.
Okay. Thank you, Ms. Iwer. Is there anyone from DENREC here that wants to make any comment? Mr. Nichols, go ahead.
Just a question. I know from speaking to staff that the policy of the Delaware Public Service Commission staff is to not make the transcript of the proceedings available to the public, that they must be acquired from the court reporter directly. Since I'm the petitioner, I'd request a special exception, if the commissioners so order, that I be granted access to the petition without having to pay for that, pardon me, access to the transcript of my petition without having to pay for that by going directly to the court reporter.
Well, I don't think we can do that, Mr. Nichols. Frankly, that's the first time I've heard make a request like that in 15 years, 13 years. I don't know that I can spend the agency's money like that.
They're supposed, I'm sorry.
Chairman Winslow, that was part of the contract negotiations with the court reporting company, that staff would not share those and that they would have to be purchased by the public directly from the company.
That's why I made the comment that we can't really pay for that out of our.
That presents a problem under the Freedom of Information Act. To charge me, well, they're already, the commission, the DPSC is already paying a fee, albeit at a discount, and then I, as a citizen, have to pay another fee.
Well,
Seems unfair.
if you want to make a Freedom of Information Act request, you can do that.
Okay, thank you.
It actually is not a Freedom of Information violation.
I would agree, but
I didn't say it was a violation, it just seemed unfair.
You do not have to, when someone makes a free FOIA request, the agency can charge a fee for the copies that are provided. And that is basically the same thing that you've got here.
Matter for another day. Thank you.
It's another contract we have with the court reporters. That's just the way it is, Mr. Nichols. Commissioner Drexler.
One final question for Mr. Nichols. My understanding from your petition is that the tariff cost is a combination of the facilities amortization cost, the cost of the natural gas, the operating cost, less the sale of the electricity to the grid. Is that
It's a shorthand way of
oversimplifying or-
trying to explain how they arrived at the $166.67 megawatt per hour tariff.
Is your, and when discussing that heat index and the natural gas price,
Yes, ma'am.
is that portion of that calculation what you're referring to, that natural gas purchase amount?
Right. Well, may I explain?
Yes.
The way the tariff operates, Bloom, for every megawatt hour of electricity they generate, is entitled to, under the tariff, receive $166.67. I believe that's the correct number, 67 cents per, pardon me? 67 cents? 87 cents, thank you for the correction. $166.87 per megawatt hour for electricity generated. In addition to that, they are entitled to the cost of the cost for the natural gas that they use to generate the electricity. That's billed, as you know, 2 months in advance. That money is set aside by Delmarva Power acting as agent, and then Bloom generates electricity based upon whatever the capacity factor is, meaning the uptime, and then that generates revenue. They sell it directly to the grid. There are 2 different markets that they sell to, trying to maximize the revenue for the benefit of the ratepayers, and the balance is what is estimated to be due 2 months in advance. Now, here's where it gets tricky. The tariff is set up so that Bloom, when they originally, well, first of all, it was a staggered deployment. They didn't put it all in line at the same time. That's something else that could come up during review. Whether or not they actually met all their obligations under the tariff for these fuel cells to be manufactured in Delaware that were ultimately sited in Delaware, but that review may not happen, but let's not deal with that. It was a staggered deployment. Initially, they were more efficient, but these fuel cells, they use an oxidation process to create electrons, sort of like a battery that doesn't run out of fuel. And over time, they become less efficient. So in order to extend the life of the fuel cells and still qualify for the payments under the tariff, they set up a banking provision so that to the extent that the fuel cells did not have a heat rate of 7.55 millions of BTU per megawatt hour, then that unused natural gas would be banked. Now, not in a real sense, but in a bookkeeping sense. They'd set the money, they'd set the natural gas aside in order to be able to draw against it at a later date when the efficiency went below the 7.55 millions of BTU. Now, they are above the 7.55 millions of BTU, and they are drawing down to their bank, and they will eventually exhaust it. Nevertheless, when they exhaust it, even though the efficiency continues to deteriorate, they will continue to be eligible for payment of the natural gas for a heat rate up to 7.55 millions of BTU. Is that fair when they were permitted to use no more than, in their documents provided to DENREC, said that they would use no more than 6.60 millions of BTUs? Guaranteed. Maximum is the word, maximum is the word they use. So the tariff and the permit didn't coincide. How is that possible? Well, we'll never know, because it appears that, at least at this venue, we won't have a review. But that's a question that someone ought to want to know the answer to. I've been asking it for 6 years now, and I'd like to get to the bottom of it. The former Division of Air Quality Director, Ali, I always call him Ali M., he's now in Oregon. They've moved him away. He's no longer here. He's doing the same kind of work that he did in Delaware, but he's doing it in Oregon. But maybe he could come here and explain how 6.60 at DENREC turned into 7.55 here at the commission. These are just some of the issues. I'm not prepared to, nor do I want to litigate. As I said, I don't want to litigate this issue before the PSC. I wanted to review the issue before the PSC. Did I answer your question, ma'am?
Yes, thank you.
All right, thank you.
Mr. Slater?
A quick clarification, as Mr. Nichols just said, this belongs to DENREC.
It does and it doesn't.
Okay, we're not gonna have that discussion. We don't, well, there's a motion on the table. Any more discussion? Hearing none, all those in favor signify by saying aye. Aye. Are there any opposed? Any abstentions? The motion carries. Best wishes, Mr. Nichols. Thank you very much for your
Thank you for the opportunity.
participation.
Appreciate it.
Thank you, Mr. Slater, Ms. Iori, Mr. Geddes.
You're welcome.
Okay, there's nothing on our hearing schedule. There is a place for public comment. Is there anyone in the public that would wish to make some comment to the Public Service Commission about something other than the Bloom matter? I don't see anybody approaching, and Denrec, does Denrec want to make any comments today? I don't see Tom Noyes here.
I wonder why.
Mr. Bruja.
Thank you, Mr. Chairman, Commissioners. Very simple. Next meeting is on October 23rd, 2018, right here, 1 p.m. Eastern Time.
Thank you all very much.
Thank
We're
you.
adjourned.